The Aligarh Muslim University was a 29-2 institution in which all the seats were available to the citizen of India until 2005. So for the first time, the citizen of India have been deprived only on the basis of their religion access to admission, consideration for admission on merits in the case of PG medical seats in 2005. The judgment in 1967 has upheld the constitutional status as a secular institution. Now, lordships are sitting in a combination of 7 judges deciding a question of seminal importance. The interpretation lordships will choose would have to be in sync with the constitutional spirit, which is upholding the doctrine of secularism, which we have actually enshrined as a basic feature of our constitution. Now, what is the interpretation which is sought to be given today? The interpretation which is sought to be given today is the original scheme of the constitution, which has conferred certain fundamental rights on an institution which is classified. My submissions in volume 2M have stated, my lords, AMU qualifies as a state under Article 12 on the day the constitution comes into force because it is maintained by the state. I've referred to section 35 in the 1920 Act and the substituted section which came in the 1981 amendment. Both of them mandate that the accounts and audit will have to be done and be published pre-independence, post-independence in the Gazette of India. In the pre-independence, in addition to Gazette of India, in the local gazette. Further, 35(4) post-1981 mandates the audit by the Comptroller and Auditor General. The finances which are going into the institution have been demonstrated, my lords. The scheme of the constitution has created certain rights in favor of the citizen of this land. Now, those rights are now being diverted or being actually taken away by a parliamentary legislation which does not seek to even refer to the judgment of the Constitution Bench, much less refer to entry 63 status. With great respect, my lords, entry 63 is a status conferred on an institution, not merely a origin or a establishment of a new institution. The historical background has been set out, my lords, by Mr. Rajeevranjan, the learned senior counsel. The background of 1916, 1920 is where we moved to a secular constitution in 1950. The new sovereign was conscious of the pitfalls of the two-nation theory and have expressly rejected it. And by rejecting it, they elevated both universities, though named as the Banaras Hindu University and the Aligarh Muslim University, as institutions of national importance. Once they elevate it, some purport has to be given to that status being conferred under the original constitution, my lords. The third point that I would like to make, my lords, is that an institution of this significance, once it is an Article 12 state, it ceases to be an Article 31 minority institution on the commencement of the constitution, because there cannot be a situation where it could have been an instrumentality of state or otherwise, but this is an institution which existed on the day when the constitution has come into force. So therefore, it becomes a state on the date when the constitution comes, and it becomes Article 12. So 31 is not available to this institution, my lords. And AMU, as a creation of the statute, through its registrar, who is also a creation of the statute, cannot actually question the constitutional status of the university, which itself is a part of the original constitution. The stream cannot question the source, is my respectful submission.
Thank you.
I'm grateful.